sticks, long-haired weirdos, short-haired weirdos, vandals, hooligans.
The government, hug the government, love the government, hug the
Welcome to the Politics Guys, presents the U.S. Constitution. The Main Politics Guys is a place for bipartisan, rational, and civil debate on American politics and policy. What we're now also bringing you are in-depth series on topics in American politics and policies. Our Politics Guys Presents series will dive deeply, 1 week at a time, into a particular element of U.S. politics. In the Politics Guys Presents the U.S. Constitution, I, Dr. Trey Orndorff, and my co-host, Dr. Ken Katkin, will be diving into the U.S. Constitution, article by article, clause by clause. This multi-year project was originally only for supporters, but is now generally available to you, the listening public. If you like these shows, remember that the Politics Guys are presenting other topics right now to supporters. So head down to the show notes to get access to all of the Politics Guys and now all of the Politics Guys Presents series. In the meantime, I hope you enjoy yourself as you join me and Ken Katkin on our journey through the U.S. Constitution. Ken, welcome to our slowish go through the U.S. Constitution.
Yeah, it's great to be back.
Yeah, it's always fun. You know, it's been a lot of fun for me. I love doing the every week, kind of the stories that are happening there. But I like the idea of kind of what we're more used to doing, which is, you know, we don't teach inside of current events. So it is fun to get into those current events and see how those are influenced by the things that we teach. But it's also fun then to kind of step back in this show and say, hey, but what are some things that you might not know if you're always doing the current event? You know,
Right.
And so having that chance to kind of understand the Constitution is a big one for me. It's one of the things, if you know, you're going to be in my introductory government class, which I know many students, they dread when they come to any school. Like, oh, gen eds, I don't want to take government. But I do really think it's important for really all citizens to have an idea of their Constitution, at least have read it, and not just have read it, but as we've seen, kind of dug into it a little bit. So you kind of know what's going on and what's happened. And so that's what we're going to be doing here in this episode today. We're going to be taking on today, Article 1, Section 9 in just a moment. So, Ken, you know, we have spent a number of weeks now, and as a matter of fact, even you and Mike were able to step in when I had a moment, and we've been working through the powers of Congress, and the powers of Congress are located in Article 1, Section 8 of the Constitution. It's one of the Article 1 is the longest of the articles, in part because we've talked about Congress was viewed as being the most important of the institutions in the federal government. But then immediately after these grants of powers, and it ends with the necessary and proper clause in Article 1, Section 8, we then move on to Article 1, Section 9. And that's what we're going to start taking on here. And these are, in fact, the powers denied to Congress. So, for example, here in the very first phrase, we're going to kind of go through this clause by clause. So let me read we're going to read each of these clauses, and then we're going to talk about each of them one at a time. And so the first one for Article 1, Section 9 is this. It says, the migration or importation of such persons as any of the states now existing shall think proper to admit shall not be prohibited by the Congress prior to the year 1808. But a tax or duty may be imposed on such importation, not exceeding $10 for each person. Now, that's a lot of kind of veiled clauses here, but this is dealing with slavery. The idea here was that could Congress ban slavery right at the outset? And Article 1, Section 9, Clause 1 says, no. And this is kind of a good setup for what you're going to see, because, of course, you might think that's the case, because we already talked about in Article 1, Section 8, one of the powers of Congress is the ability to regulate commerce with foreign countries, but not in terms of slavery. So, Ken, obviously, we're past 1808. We fought a civil war. This first clause, while it may be a good example, it doesn't serve much actual lifting power in the Constitution, other than maybe pointing out to those who don't recognize it the importance of slavery on the creation of the Constitution.
Yeah, I mean, the Article 1, Section 9 begins with depending whether you're a glass half empty or glass half full type person, it's either one of the most shameful clauses in the Constitution because it actually says even though Congress has the power to regulate foreign commerce with foreign nations, the one and only kind of commerce that Congress can't prohibit is the international slave trade, the importation of slaves into the country. That has to be allowed to continue for another 20 years before Congress can even consider using its enumerated power to regulate foreign commerce and banning the international slave trade. So that's sort of the glass half empty view of it. I guess the glass half full view of it would be to say that this shows that even on day one, like the minute that we seated a U.S. Congress, the votes would have been there right away to ban the international slave trade. And that's why they felt that it was necessary. The slave states said, we're not going to join the Constitution. We're not going to ratify the Constitution unless we get some assurances that the international slave trade won't be banned right away, because we know that otherwise Congress would ban it right away. And in fact, as soon as the 20-year sunset passed, the year 1808 is mentioned in that clause, Congress immediately, the very first day that they could, they banned the international slave trade. So some people would say that this shows that we were really an anti-slavery country at heart, but had to make some compromises with slavery. Whereas other people would say, well, no, we actually, protected slavery in our Constitution, even against initial early democratic change through legislation.
Now, of course, the glass half empty side is to say, well, the reason you might immediately say, oh, wow, there were a lot of individuals against slavery, but there were economic reasons why individuals might want to vote against that importation that would not have included ending the slave trade, but rather making their own property worth more money.
That's true, because this is only a ban on Congress is going to be given some power after a 20-year sunset to end the international slave trade. And arguably, Congress could have even used its power to regulate interstate commerce to ban the interstate slave trade. But the Constitution, as understood by the framers, would never have given Congress the power to ban intrastate slave trade. So if you start banning, bringing in more slaves, it does raise the value of the slaves that are already here, which I think was your point. Yeah.
Now, today, of course, this is it's useful for understanding that mechanism. But again, as you noted, it has more to do with understanding the Constitution as a moral document than it really has any kind of meaningful continued legal significance.
Yeah, but that's what it's just that's right. I don't think we're in too much danger today of Congress legislating to permit the international slave trade again. In fact, we have the 13th Amendment now, so that would actually be unconstitutional. All slave trade is unconstitutional after the 13th Amendment.
Exactly. I want to get there as we move forward. Now, so the second clause of Article 1, Section 9 is this. It states, the privilege of the writ of habeas corpus shall not be suspended unless, when in cases of rebellion or invasion, the public safety may require it, end quote. So now, habeas corpus, this is one, I don't know, maybe listeners have heard of, but you don't recognize it. But it's this idea of you got to produce the body. You can't be held without having some kind of presenting before a judge. And it actually goes back to the Magna Carta. It's kind of the first location where that happens. The idea is that you can't have Congress, in this case, locking individuals up without the ability of them to be before a judge. So that's a pretty important one, Ken. What should we know about that?
Well, one thing is about the habeas corpus clause. It's one of, there's several examples you'll find in the Constitution of how the framers were not perfect drafters, because although Article 1, Section 9 does prohibit Congress from suspending the writ of habeas corpus except under certain circumstances, they actually forgot in Article 1, Section 8 or in Article 3, perhaps maybe it would have belonged there with the judicial power. But there's no part of the Constitution that authorizes the grant of the writ of habeas
Right.
corpus. There's just a limitation on when it can be suspended. So so I think that's a drafting error. But certainly the framers obviously thought that courts had habeas corpus jurisdiction, which is a jurisdiction that English courts had, as you said, since the Magna Carta, and the concept of it was that as a protection of civil liberty, if anybody was being detained or jailed or just not free to walk around, they had the right to go into a court and challenge the authority or the jurisdiction of the detaining authority to detain them. So, this went back to the days of strong monarchy in England, and one of the early kinds of civil rights that at least the English aristocracy was able to obtain for itself was that the king should not be allowed to just arbitrarily jail people, but that if the king grabbed somebody, had them arrested and jailed, maybe holed up in the Tower of London or something, that there should
Just
be
for
a
an
right.
example.
Just for an example, yeah, that people should have a right to petition a court, and then the habeas corpus, as you said, bring me the body. The king's men would have to produce that person who was being detained at the Tower of London. They'd have to bring that person into court and answer the petition and explain, by what authority and for what reason are you locking this person up? And if the court concluded that that there was not a valid, lawful reason to justify the detention, or the detaining authority actually lacked authority to even authorize the detention, then the court would, right there in the courtroom while the detainee was there, would order, they would grant the writ of habeas corpus, and that's a court order ordering that they be set free, that they could walk right out of the court right then and there. And we have that privilege to this day, and it is primarily used, probably these days, primarily used for by people who've actually been convicted of crimes and they're being held in prison. But they will argue to some extent that there was something unconstitutional, either about the law that they were convicted under or about the conduct of the trial, that the trial didn't meet constitutional requirements. So that's how most modern petitions for habeas corpus come into court. But there also have been other uses for them in modern times. And the writ became very important during the war on terrorism, when you had all the detainees at Guantanamo and elsewhere. That again, the writ of habeas corpus was the basis for those detainees to challenge their detentions, and they did have some success at the Supreme Court. In fact,
Well, I want to say, I'm going to pause you for just a second, Ken, because we need to take just a moment. Okay, so Ken, when we were a moment ago, you were talking about how the most recent incarnation of invoking habeas corpus had to do with Guantanamo Bay, right? So we have this location where we're holding enemy combatants, at least under the language of then President Bush, but then not allowing them to have the normal trial process, and therefore asking to be in front of a court. So maybe to extend the idea of that Tower of London, hey, you've got to bring people from Guantanamo. They get to be with their lawyer, and they have to become in front of in front of a judge, and talk more about that now. Yes.
Yeah, so I would say nothing was normal about the war on terrorism, because one other a lot of detention, as you sort of suggested, happens because someone's been accused of some crime or convicted of some crime. But in war, people are also detained as prisoners of war, right? So just the mere fact that they're members of an army of a country that we are fighting a war against, they're captured so that they can be removed from the battlefield. They're held for the duration of the war. They don't have to be accused of having done anything wrong. Just the mere fact that they're taking up arms against the United States justifies holding someone as a prisoner of war. But what happened in the war on terrorism was, the Al Qaeda attacked this country, and our Congress authorized the use of force in retaliation. And we had a sense that the Al Qaeda attacks had been launched from Afghanistan, that Osama bin Laden was in charge. We probably knew a few other people that were involved. But by and large, when that all happened, the U.S. Armed Forces and the U.S. intelligence services didn't really know, who all the people were who were in Al Qaeda. And when we went over to Afghanistan, and even some other countries in that region. And the mission is, round up everyone in Al Qaeda and take them prisoner of war. We didn't have very good tools for figuring out who it was that we were trying to round up, and probably the most common tool that we used was reward money. So you'd have U.S. military or intelligence personnel going around to areas where it was thought that Al Qaeda operated and saying, we'll pay bounties to people who tell us who's in Al Qaeda. And so that led to a lot of people taking money and naming names, and about 800 people total being rounded up. And as you could expect from using that kind of intelligence gathering, the large majority of them were completely innocent and had nothing to do with Al Qaeda. And so this led to a situation where you have all these people grabbed out of Afghanistan because their neighbors decided to make a few bucks by saying that they were in Al Qaeda, and they're brought to.
We all have that
Bay.
neighbor. Let's be honest.
Yeah. They're brought to Guantanamo Bay in Cuba, and they take advantage of the writ of habeas corpus, and they start filing petitions in federal district courts. And Congress was not crazy about the fact that the habeas corpus mechanism was available here. And Congress actually passed a series of statutes between 2003 and 2007 trying to cut off the use of the writ of habeas corpus by these Guantanamo detainees. But the Supreme Court kept saying in a series of cases, the final one being a case called Boumediene versus Bush, that the privilege of the writ of habeas corpus shall not be suspended by Congress, because that's what it says in Article 1, Section 9, and that although there is a safety hatch in Article 1, Section 9, that the privilege can be suspended when in cases of rebellion or invasion, the public safety may require it. The court found that by 2007, when the last of those statutes was enacted, 6 years after September 11th, that we were no longer in a time of rebellion or invasion, and Congress had not made the finding that we still were. And they did not allow a suspension of the writ, and they actually ordered the military to give review proceedings called combatant status review proceedings to each of the detainees who wanted to make a claim that they were not members of Al Qaeda and they'd been wrongly identified. And the court also said that if those detainee proceedings, the combatant status review proceedings, didn't proceed in a timely way or weren't fair enough, the courts, federal district courts, would still backstop that using the writ of habeas corpus. And in the end, I think the way the numbers broke down, out of the 800 or so people that were ever detained there, 40 of them remain in detention today. And I guess we can assume that those people were real Al Qaeda members.
Yeah.
But of the more than 700 who were grabbed, all the rest have been released by now. Some of them were released into the custody of other law enforcement of other countries, so they weren't completely exonerated. But there were no more than about 100 that fit that category. I'll have to admit there were also some who were released who then joined, did more terrorist acts afterwards.
Right.
So they were wrongly released, I guess, but or radicalized while they were detained. But that ended up being about 80 of them. And so I think under the most generous count, if you say, well, everyone that's still there, plus everybody that committed acts of terrorism after they were released, plus everyone that was released to the custody of other countries that were going to keep them in jail, that still only adds up to about 200 out of the 800. So I think it is about 600 at least who, were wrongly detained, who were found to have been wrongly detained, who were let go, and who never caused any problems again after they were let go. And a lot of them might still be there if it wasn't for the privilege of the writ of habeas corpus. So that played an important role in trying to restrain the war on terrorism to certain kind of rule of law principles. And as I say, the other kind of very common use of habeas today is it'll be used by people who've been convicted of crimes, generally in state courts, and they'll say, well, the state trial did not meet constitutional standards. And sometimes the federal courts will take a look at that, although the success rates on those kind of petitions are very low, like less than 1%. So most petitions for habeas corpus that get filed by people convicted of crimes in state court, the court will have a proceeding on them, but they won't generally grant those petitions except in very special cases.
Now, in the case of the 800 you were talking about, of course, we did have the one who was a U.S. citizen, Hamdi, right, who gets sent originally to Guantanamo because officials didn't recognize he was an American, but he also doesn't he have a similar case? Now, eventually, though, Hamdi, he renounces his U.S. citizenship and I believe still lives in Saudi Arabia.
Yeah, the other thing about his case that was interesting was it was a 5-4 vote, but the majority in the court actually did not think it was significant that he was a U.S. citizen. So the majority said that the same exact rules apply to U.S. citizens as to non-citizens. Again, that rule being that everyone in Guantanamo, in his case, he wasn't in Guantanamo. He was when they found out he was a citizen, they brought him to a naval brig in Virginia. But even for him, everyone, whether they're citizen or non-citizen, they'd be entitled to have a administrative combatant status review tribunal hearing before a military tribunal where they could argue that they were not actually members of Al Qaeda. And so he was entitled to that, but so were all the non-citizens, and those would be backstopped by potential availability of habeas corpus in federal court. If the combatant status tribunal didn't happen or if it didn't unfold fairly. But there were 4 justices who thought that was not an appropriate mechanism for a U.S. citizen. And Justice Scalia had an opinion where he said, if the government believes that a U.S. citizen took up arms against the United States, then the government should charge that person with treason or they should let them go. And they shouldn't just be detaining them on the theory that they're an enemy combatant. And so that opinion was agreed to by 4 justices, but the majority actually in the Hamdi case found that the same exact procedure should apply to him as to all the others, and that actually included the procedure that if the military tribunal concluded that he was a member of Al Qaeda, then even though he was a U.S. citizen, they could just continue to hold him as a prisoner of war in a military brig rather than trying him with a crime.
Okay, so Ken, I think it probably was time to move to the third clause of Article 1, Section 9, and that says, quote, "No bill of attainder or ex post facto law shall be passed." Now, this was a really big one, again, coming from the British system and the monarchy. And this is the idea that you can't have a law that makes something that was legal in the past illegal now, and therefore you could be charged with the committing of the then legal, now illegal act, right? So, I crossed the street in an improper way, but now, but it wasn't when I crossed the street. So what do you do about that? So that's obviously an interesting one. But what's this bill of attainder? I think a lot of individuals are not sure. What does it mean? You can't have any bills of attainder, Ken?
A bill of attainder is a law that makes it a crime to be a certain person. So, sort of the distinction between the bill of attainder and the ex post facto law, if the Congress would pass a law today that says it is a crime to be Trey Orndorff or Ken Katkin, and if the prosecutors can prove that someone is in fact Trey Orndorff or Ken Katkin, then that's all it takes to send them to prison.
I want you to know right now that my legal name is Harold Orndorff III. I don't know who the heck this Trey is.
Try to escape out from it. Yeah, that would be a bill of attainder. Whereas, as you said, an ex post facto law, it functions in a similar way, but formally it's a little bit different. But the idea would be to say, well, it's a crime to have been the host of the Politics Guys podcast in the year 2021. And they just enact this now in 2023. And then they go and prove that you and I were hosts of the Politics Guys podcast in 2021. It wasn't illegal when we did it, but now they're retroactively making it illegal. So both of those provisions, they're just different ways of getting at the idea that the legislature should be legislating prospectively, making laws prospectively, and that the legislature should not be deciding after the fact who they want to say is a criminal.
In other words, it's supposed to be about generalized lawmaking, not, for example, maybe coming after somebody personally, for example.
Yeah. Bill of attainder is the most direct one on that. Bill of attainder literally is coming after someone personally, and it's not allowed. And ex post facto law is, I think, also coming after someone personally, but it's more indirect. It's doing it by making it illegal for them to have done something in the past that they already did, and that would be a way of coming after them. I think the best way to think about these things, besides the sort of obvious thing, which is that they protect civil liberties of individuals, is that they're also separation of powers provisions, because I think the thread that connects them is that we don't have legislative trials, right? The legislature makes the laws, but the legislature doesn't decide, doesn't execute the laws, doesn't decide who's guilty or innocent. Right. And bills of attainder, ex post facto laws would be mechanisms by which the legislature could actually, define and decide, who's guilty. And so, that's supposed to happen through separation of powers. The legislature should make the laws, the executive should bring the prosecutions, the judiciary should decide who's actually guilty.
Now, as we move forward to the fourth clause in Article 1, Section 9, this is actually one we've already talked about, Ken. I'll still read it here for a minute. But this has to do with taxes. And so we had already really talked about direct and indirect taxes and the court cases that deal with it. But what it says is that no capitation or other direct tax shall be laid unless in proportion to the census or enumeration therein before directed to be taken. So again, I would really encourage you, if you want to go deeper into Clause 4 of Article 1, Section 8, that you'll need to take a look at our earlier episode on that. So I'm just going to move us forward, Ken, to the next one, which is being laid on articles exported from any state. Now, one of the things, and we'll talk about this, states have power denied to them, and one of the things they're not supposed to be able to do is to basically set their trading relationships up with one another as you might foreign countries. But in this case, it's also saying that Congress can't allow there to be taxes or duties for those goods passing between states either. Why is that such a big deal?
Well, or foreign exports as well. So I think the main focus of that provision is on articles exported from any state is that even though we can have import duties and import tariffs levied by Congress, we cannot have export duties levied by Congress. And that's a provision. You could say that's a mercantilist provision, actually. It's to make sure that our businesses are allowed to sell to other countries in an unfettered way. Even though Congress could put tariffs on and, try to prevent other countries from selling to us. But you're right. It also does apply or probably in the framers' view, did apply to federal taxes on the movement of goods across state lines. And that would be part of the idea that the Constitution was establishing an internal free trade zone. Now, I think in modern doctrine, the Commerce Clause and the Dormant Commerce Clause are the primary vehicles for that. And I think modern doctrine does not apply the Export Clause of Article 1, Section 9 to interstate exports, although Justice Thomas, in a few recent opinions, has argued that it should. I think the modern doctrine would generally defer more to Congress and say it's up to Congress to decide what the rules for interstate commerce should be. There's sort of a default presumption that it's a free trade zone, but Congress is allowed to tinker around with that a little bit under modern doctrine. But I think you're right that under a original understanding and under probably a plain language reading of this clause, it would seem also to say that Congress can't levy taxes on goods that are exported from one state to another. And certainly Congress hasn't done that.
Right. I mean, there was really no reason to want to. Well, I mean, one of the things I think sometimes students will get at that say, well, why doesn't it come up? And the answer is, well, if there's no push or desire and you never have a precedent for it, it kind of almost lays dormant until eventually it becomes a moot point because it's just not something that ends up being an issue. And so you can speculate about it, but okay, we speculated about it. Let's move forward. So, quote, no preference shall be given by any regulation of commerce or revenue to the ports of one state over those of another, nor shall vessels bound to or from one state be obliged to enter, clear, or pay duties in another, end quote. Now, I mean, this obviously is dealing with, and one of the big worries is which states would be considered the most important, and could Congress, if they were controlled by those states, be able to make to benefit themselves by having preferential treatment or forcing goods to come through a particular state as it moves forward. That's been my general reading and understanding of this clause. Am I missing anything, Ken?
No. I mean that's how I understand it too, and it's another one that doesn't really come up in modern litigation, but
Right.
I think the concept would be, yeah, if if the New York delegation in the House was bigger than the Maryland delegation in the House, then maybe New York would have the strength political strength to say, we'd like to charge higher import duties on ships that come into Baltimore Harbor than ships that come into New York Harbor, and that would be a way of kind of leveraging their electoral strength into getting more international trade coming to their ports, and that kind of thing is prohibited by this clause. But again, it's one that really doesn't come up very much.
I mean, one of the things when I look at Article 1, Section 9, and we're kind of getting through some of these, is that it's hard to overemphasize how worried small states in the original 13 and is moving forward were about the pre-existing large states, which in some cases didn't have definitive Western boundaries and or what the size of states moving forward would be, and therefore worried that there would be a lot more what we might think of as being kind of European power plays, country power plays between one another, potentially taking place between states. And like you noted, this doesn't really come to be a big deal, but that I think that's part of the reason you see some of these things in Article 1, Section 9.
Yeah. Yeah. But I mean, for the whole 200 years, if a boat lands at, no matter what harbor it lands in the United States and starts unloading its goods, the import duties are going to be the same for the same goods. They don't vary by harbor.
Right. Okay, so let's move forward to the next clause. No money shall be drawn from the treasury, but in consequence of appropriations made by law, and a regular statement and account of the receipts and expenditures of all public money shall be published time to time. Now, this is a little bit more of a complicated one, Ken. Well, what does this mean in terms of it has to be made in consequences of appropriations made by law?
Yeah, I mean, there's rampant violations of this clause in the modern world. So the concept of the clause is that Congress, as we talked about in last time, under Article 1, Section 8, Congress has the power to spend money, to appropriate funds, to provide for the general welfare and the common defense, and Congress has power of the purse. But what this is saying is that, for one thing, that power exclusively belongs to Congress. So the president and the executive branch cannot spend money out of the Treasury, even though they have the Treasury, right? The Treasury Department's part of the executive branch, but the president can't tell the Secretary of the Treasury to spend money on things that Congress hasn't authorized. And also the public should have accountability. There has to be, not only does Congress have to authorize the appropriations, but that has to be published. The regular statement of accounts and receipts and expenditures. So the budget that Congress appropriates has to be published. The actual checks, that the Treasury writes, they can be summarized. So, if the Treasury's sending out Social Security checks to millions of Americans, it's not that we can look at every one of those checks sent to every American, but we're supposed to be able to look at a bottom line number of how much does that total up to.
Mm-hmm.
And so the regular statement and accounts of receipts and expenditures, this is all supposed to be public record. In the 20th century, the compliance with this has just become less and less perfect, and there's enormous amounts of spending, primarily within the military budgets, but
Yes.
here and there elsewhere, that are just simply not disclosed. You could never find out what's even been budgeted or what's been spent, and it's not. And I think there's quite a lot of money that does get spent that hasn't been appropriated, and so there's very imperfect compliance with this. So the concept was supposed to be both a rule of law concept and a public accountability concept, that money shouldn't be spent unless Congress authorized the expenditure, and that the public should actually be able to look at all the at the books and see what revenues came in, what expenditures went out. But because of doctrines that we'll get to when we get to Article 3 a little later in our series, justiciability doctrines, particularly the doctrine of standing, which did come up a lot recently in the student debt case
Right.
that we talked about. The court has consistently held that if somebody wants to bring a lawsuit and say, I'm a citizen I would like to see the statement, an account of the receipts and expenditures of the National Security Agency, of the some of the other intelligence agencies of the money that's going to pay for all the surveillance programs. The court will consistently say, well, that plaintiff doesn't have standing to bring that case, so therefore, even if the government is violating Article 1, Section 9 by not publishing the regular statement and account of receipts, and maybe even by spending money that was not actually appropriated by Congress, there's nothing a court can do about that because nobody's got standing to bring that claim.
No, that's always a weird one because you both have to have a right, and then you have to have the ability to demonstrate that you have the ability to bring that to a court, as you're calling judiciability. And now this is always there's two pieces to this that I have of interest. One, of course, is the amount of leeway that we have given in terms of, and in this case, even as you've pointed out, and I hadn't even thought about how blatantly. When it comes to military matters, how much we're willing to wink when it comes to constitutional provisions, which is always, I mean, maybe some of this is just the libertarian in me coming out, but it always seems to me like that's precisely where you ought to be the most worried, right? If anywhere, it's there. From your point of view, obviously not a libertarian, what do you think about that on that front?
Well, I'm with you on that. And actually, weirdly, I think there were a handful of moments in the Biden administration, not Biden, in the Clinton administration.
Oh, I was
not Biden. No, in the Clinton administration and the early Obama administration, I think both of those presidents came in and were sympathetic to the views that you and I are expressing. And even though they, never were going to really buck the military that much and publish any kind of detailed budget numbers, they did publish top line numbers, which mostly hadn't been done in years prior. And they both caught like huge amounts of blowback that, if we even disclose that the total budget for if the Russians and the Chinese can even see that we're spending $50 trillion on the National Security Agency, even though we wouldn't give them any detail at all on where that money's going, if the public could see that, then the Russians and Chinese will see that, and if they see how much money that is, that's going to cause harm to the national security. Even those presidents who once or twice did publish top line numbers like that did not persist in publishing those top line numbers, so that they all were cowed into going back to not publishing them. So you get a few little windows in time where some presidents have said, I think we can go ahead and publish a statement of accounts and receipts and expenditures of public money the way the Constitution says we should, if we do it in great generality and don't get into much detail. And even that was too much for the military industrial complex, I guess. And
on left and
I don't
right.
like that. Yes, I don't like that at all. I'm totally with you on that. I would like these numbers to be published. And, when we hear, a lot of discussions about, there's going to be a debt ceiling, there's big deficits, there's maybe going to have to be reforms to Social Security, like in France and all this, it's that debate is very incomplete when we don't see where these huge amounts of money are going, or even the fact that they exist and that they're going anywhere.
Yeah. Well, yeah, and that's one. I mean, we won't solve that here, but how do you have open and free debate over something that you can't know about? Is it's impossible. Now, the other half of this, though, that comes up, and this I believe is a Nixon item, is right. So you can't have any money drawn from the Treasury, but in consequence of appropriations made by law. But could a president just choose to not spend the money? The other flip side of that, the court actually deals with that and says, no, you can't do that either.
Well, they sometimes allow it. So that's called impoundment. And I think the exact rule that the court laid down, which comes from you're right, a Nixon era case called United States against Train. The court says, if Congress says in an appropriation, we're appropriating this X amount of dollars and it must be spent and it may not be impounded, then that is binding on the president, but which is the part that you were talking about. But on the other hand, if Congress just does kind of the ordinary budgeting thing, we're going to give X amount of dollars to the Department of Education to subsidize student loans, and they don't say and they have to spend it all, then the default rule actually is that the president can sometimes impound some of it. Presidents don't have to spend the amount that's been appropriated unless Congress expressly tells them that they have to spend the amount that's been appropriated.
But now we come to the last clause, and until recently, it probably wouldn't have been have any kind of contemporary holding in many ways. But it's this: no title of nobility shall be granted by the United States, and no person holding any office of profit or trust under them shall, without consent of the Congress, accept of any present emolument, office, or title of any kind whatever from any king, prince, or foreign state. And that's the end of Article 1, Section 9. I mean, in short, the idea is you can't have ties or be involved financially with other states if you're going to be in office. Now, of course, this comes up most recently with President Trump when it comes to individuals coming and staying at his estate so that he's getting money potentially from foreign states because they're coming to meet with him as president of the United States. And this is something that actually came up, during his administration.
Yeah, I think it was actually his hotel that they were staying at. So
Mar-a-Lago.
Oh, well, the one right across from the White House. He had a hotel in Washington, D.C.
Oh, that's right.
Right across from the White House. And he had actually managed to get the lease on that hotel before he got elected president. So it was very serendipitous for him that he got elected president. But then, in his hotel that was right across from the White House, they started charging $5,000 a night for a room there. And all these foreign dignitaries kind of got the idea, well, no matter how high he's charging for a room,
I better stay there.
We better stay there. Yeah. And that's going right into his pocket. So I think there was a pretty good argument that the president was holding office and that he was profiting by accepting presents or emoluments from kings and princes of foreign states or just from foreign states themselves. So I would say he was in violation of the emoluments clause by that stuff. The other part of it, no title of nobility. So, the United States doesn't have titles of nobility. You can't be a duke or a lord or a prince here. And
what does that mean for Jay, though, in his title? is there any? Sorry, go ahead, kid. Go ahead.
You still there, Trey?
Oh, yeah. I said I was just teasing. Yeah. Go ahead.
Yeah. Oh, no, I didn't know Jay had a title. Well, now, when we get to Article 1,
he's the defender of freedom.
Oh, defender of freedom, that title. Yeah, well,
I was just teasing. Yeah, exactly.
We can have titles as long as we don't get them from Congress. I thought you were going to, when we get to Article 1, Section 10 next show, and we see the same exact clause about titles of nobility, but it's that no states shall give it. I always get a little nervous about that one because I am a Kentucky colonel. I don't know if you are.
No, I'm not. I don't have anything like that.
Yeah.
I was too poor. I'm not rich like you can.
Yeah. So I'm gonna assume that Kentucky colonel's not a title of nobility, although I think of it as one.
Okay, that's too funny. That's.
But yeah, so that's what that could. But the emoluments clause is primarily about not accepting presents or gifts from foreigners while in office, and it applies to everybody holding office under the United States.
Now, do you think this is another one again in terms of the Trump era? Do you think this is one that could actually? It's never been used. It's never come up, and even more recently when it might have been, it hasn't had any kind of teeth to it. Do you think, kind of like as you were noting a moment ago, and over the necessary to publish those expenditures, do you think this is kind of one that also has lain dormant in that sense?
Yeah, well, first of all, it's not a criminal statute, so it would be hard to enforce, right? If somebody violates it,
you do,
the only way that the only way they could get in trouble would be if the same conduct that violated this also violated some criminal statute, like an anti-bribery statute or something. But it's not directly enforceable in a criminal case. It seemingly is an impeachable offense, but if the votes aren't there to impeach, then there's not that. The other thing I thought was interesting, there was a civil lawsuit against Trump in the emoluments case with the Washington, D.C. hotel. And I thought that the plaintiff had done a fairly good job of establishing standing, but the court did find no plaintiff had standing. But one of the plaintiffs that actually brought the case was a competing hotel, right? So the competing hotel says, we're losing business here because the president is violating the emoluments clause, and he's able to, no matter how high he charges, certain clientele will just think they have to go there. And so we're not able to fairly compete against him because of his violation of the emolument clause. And to me, that should have satisfied the Supreme Court's requirement of particularized injury in fact that's judicially redressable. But, the standing has been a very manipulated doctrine, and the court, uses it to get rid of cases they want to get rid of and keep cases they want to keep. And I think this was no exception there because they weren't persuaded by that argument.
Well, Ken, I guess we're going to need to pause there because we've come to the end of Article 1, Section 9. And so next time we come together, we're going to take on Article 1, Section 10, which is the powers denied to states. So here we have, 8 and 9 kind of go together. You have the powers of Congress and you have the powers denied to Congress. And then we're going to finish out Article 1 next time as we take a look at Article 1, Section 10. So, Ken, it's been a lot of fun continuing to go through the Constitution with you.
Absolutely. This is great.
So if you've listened to this, that means you are already a supporter of the show. So I just want to take a moment to say thank you so much for that. And I'll just say, look, the only reason we can do what we do is because of you. If you're listening right now, that means you're a supporter of the show. And you know about all the opportunities that you have. You're getting the ad-free version. There's Discord. There's a lot of other things. But keep in mind, your level of support determines what you're getting. So maybe you've really liked listening to the Constitution with me and Ken, and maybe you'd like to chat with us a little bit more on Discord, and so you want to go in there and up your support, or maybe like Ivan English did this past week, you want to be an executive producer of the show and get your name at the end of the show. Well, we would love for that to be the case for you. So remember, you can always take a look at patreon.com/politicsguys for those levels and what you're going to get. And of course, in the show notes, as always, you're going to be able to see all those different items. Now, if you're a supporter, don't forget, in addition, as you can always, Facebook and Twitter. For many of you, you're going to be able to hop on Discord. I know this week we've been having a really big conversation about what goes on in terms of, I was celebrating Down syndrome this week. It was crazy. Sock Day. I don't know if you knew that, Ken. And we were posting things on there. And that led into a big debate about abortion and about all kinds of fun stuff, the philosophy of who should live and what that might mean. I've been having a lot of fun. As a matter of fact, as we've been recording the show, I've been getting notifications. That conversation is going on live as we speak right now. I haven't been able to respond because we're recording the show. But I'd love for you to have that voice in there too. So again, if you head to patreon.com/politicsguys, you can make sure that you're at the level of support you would like to be. And even as a supporter, don't forget, sharing episodes with your friends and family is a huge way about making the Politics Guys in a very free way available to more. So thanks so much if you've been listening to this, because that means you are a supporter. Thank you. The executive producers of the Politics Guys are Bruce Johnson, Wilma Marino, Andra Masker, Daniel Toe, Ryan Beasley, Don Oglesby, and Ivan English. We'll be back with a new episode this weekend. I hope you'll join us then.
This podcast is part of the Democracy Group.